Prospectus and commencement of business. The first stage is collection of subscribed capital, the capital committed by the subscribers to the memorandum. Amount has to reach the company's bank account from the respective shareholders' account. As share certificates are required to be issued within 60 days of incorporation, it implies the amount has to be raised within 60 days, although there is no specific condition in the Act as to the time limit for bringing the capital. Where the company was incorporated with a temporary address, within 30 days of incorporation, INC 22 has to be filed indicating the permanent address of the registered office to facilitate its verification by the registrar of companies. Company is required to file within 180 days of incorporation Form INC 20A confirming that every subscriber to memorandum has paid the value of shares agreed to be taken by him, and this is essential to obtain a certificate of commencement of business for a public limited company. On the failure of the company to obtain business commencement certificate, it might result in proceedings to remove the name of the company from the register of companies, and this will also entail penalty for the company and also penalty on every officer in default. Section 2, subsection 70 defines a prospectus as a document, notice, circular or advertisement inviting offers from the public for purchase of securities of a company. It includes a red herring prospectus under section 32 and also shelf prospectus under section 31. As for form and content, prospectus needs to be dated and signed. It should state such information and set out such reports as specified by SEBI. Before the date of publication, it must have been delivered to registrar for registration, signed by every director, and its validity is 90 days for the purpose of issue, which starts from the day it was filed with the registrar for registration. There is a strict penalty on prospectus issued in contravention of the provisions of this section. Company is punishable with fine, and every person who is knowingly a party to the issue of such prospectus shall be punishable with fine, and the fine ranges from 50,000 to 3 lakhs or imprisonment up to 3 years or both. A red herring prospectus is filed with the registrar at least 3 days before the issue opens, and definitely it is issued prior to the issue of a regular prospectus. It does not include complete particulars about the quantity of shares on offer and the exact price that the shares are going to fetch. To make good the deficiency of red herring prospectus, at the time of closing of the offer, the prospectus stating the total capital raised and the closing price of the securities will be filed with registrar and SEBI by the company. The speciality of shelf prospectus is that it can be used multiple times on one or more issues over a specific period, and this avoids the requirement for issue of a further prospectus when it comes to one or more issues. The additional requirement in respect of shelf prospectus is that every time an offer of securities is made under shelf prospectus, company is required to file an information memorandum with the registrar. The information memorandum contains all material facts relating to new charges created, changes in financial position, and other prescribed changes which have occurred between the previous offer and the succeeding offer. Memorandum plus shelf prospectus becomes equivalent to a regular prospectus. Shelf prospectus has got a validity of 1 year. The 1 year starts from the opening of the first offer, and in respect of second offer or subsequent offer, during the period of validity, no further prospectus is required to be issued. Deemed prospectus is a variant of prospectus which is used by a company to offer securities for sale to the public. In terms of applicable provisions, deemed prospectus attracts all provisions on content and liabilities as are applicable to a regular prospectus. Any document which is used in a rights issue giving the members a right to renounce in favor of others, where the others exceed 50 in numbers, the document becomes a deemed prospectus and attracts all enactments and rules of law regarding the contents of prospectus and the liability for any misstatement and omissions from prospectus. A prospectus is required to be issued when you are mobilizing money from the public for a public company. Instead, if you are raising capital from friends, associates and underwriters, it is not required to issue a prospectus. Only a statement in lieu of prospectus needs to be filed with ROC. The contents of statement in lieu of prospectus will be similar to prospectus but will be very brief, and the information will be strictly as required in terms of Schedule 3 of the Act. A statement in lieu of prospectus needs to be signed by all directors, must be filed with ROC at least 3 days before any allotment. When a private company converts itself into public, it needs to file a statement in lieu of prospectus with the ROC as it ceases to be a private company. A company failing to file a prospectus or statement in lieu of prospectus cannot proceed with allotment of shares. The matters to be stated are simple and specified. Names and addresses of registered office of the company, company secretary, CFO, auditor, bankers, legal advisors, underwriters, dates of the opening and closing of the issue, declaration about the issue of allotment letters and refunds within the prescribed time. So include a statement by the board of directors about the separate bank account where all monies received are to be transferred, and disclosure of details of all monies including utilized and unutilized monies out of previous issue, details about underwriting of the issue, consent of directors, auditors, bankers, experts and of such other persons as may be prescribed. Crucial details on the authority for the issue and details of the resolution, procedure and time schedule for allotment and issue of securities, capital structure of the company, main objects of the public offer, terms of the present issue and main objects and present business of the company, its location and schedule of implementation of the project. Particulars relating to the management perception of risk factors specific to the project, gestation period of the project, extent of progress made in the project, deadlines for completion, any litigation or legal action pending during the last 5 years immediately preceding the year of the issue against the promoter. It shall also specify minimum subscription, amount payable by way of premium, issue of shares otherwise than on cash, details of directors, their appointment and remuneration, and extent of their interest in the company, and also disclosure in such manner as may be prescribed about sources of promoters' contribution. It shall also provide reports from auditors in the form of financial information on profits and losses for each of the 5 financial years, along with the reports of its subsidiaries, reports upon profit and loss account and assets and liabilities on the date not more than 180 days before the issue of the prospectus, and reports about business or transactions to which the proceeds of the securities are to be applied directly or indirectly. Under declaration and others, there will be declaration about the compliance of the provisions of Companies Act, Securities Contract Act, SEBI Act and the rules and regulations made thereunder, and you shall also state such other matters as may be prescribed. The copy delivered to ROC with attachments will indicate on the face of it that a copy has been delivered for registration to ROC. It will specify any documents required to be attached to the copy so delivered. The date indicated in the prospectus shall be deemed to be the date of its publication. No prospectus shall be issued unless a copy thereof has been delivered to ROC. It shall be signed by every person who is named therein as a director. Where a statement made by an expert is included in the prospectus, his written consent to issue has been obtained and mentioned to that effect in the prospectus. Public offer means issue of securities to public by a public company after complying with provisions of Part 1 of Chapter 3 on prospectus and allotment of securities. Public offer in its simple form can be an initial public offer or a further public offer. When a public offer is made by an existing shareholder, it can take the form of an offer for sale. Three more variants of public offer from a company are rights issue, bonus issue, or a private placement under section 42. In every public offer, the application form is required to be accompanied by an abridged prospectus, which is a memorandum containing salient features of a prospectus as specified by SEBI. However, the full prospectus shall be maintained at the office of the company, and a copy of the prospectus shall be made available to anyone who requests for it before closing of the offer. Failure in giving a copy of the prospectus as above can attract a penalty of Rs 50,000 for each default. Abridged prospectus is a memorandum containing the salient features of a prospectus. It is a virtual summary of a regular prospectus as filed with the registrar, a ready reckoner to an investor. Section 33 subsection 1 says, when any application form for the purchase of securities is issued by a company, such application form must be accompanied by an abridged prospectus. As per section 29, public companies can make an offer only in terms of dematerialized form. Even the promoters are required to hold their shares in the dematerialized form. And post December 2018, even unlisted companies are prohibited from transferring shares unless such shares are in dematerialized form. To comply with requirements of section 40, every company making a public offer before it makes the issue approaches one or more recognized stock exchanges to obtain permission for their securities to be dealt in such stock exchange. A company making public offer has to receive minimum subscription within 30 days of issue of prospectus. It should also receive the application money on the minimum subscription, which is not less than 5% of the face value of such shares during the same period. Once these two conditions are fulfilled, the company can proceed with the allotment and file a return of allotment with the registrar of companies. If the company fails to receive the minimum subscription within 30 days of the issue of prospectus, it is bound to return the money within 15 days from the closure of the issue. If it is not paid, the directors of the company, as officers in default, will be liable to repay with interest at the rate of 15% per annum. A private placement offer letter is used to invite subscription for securities, and it is given to a select group of persons. The composition of that group should not exceed 200 for each kind of security individually. Unique features in respect of private placement offer letters is that all money is payable through banking channel, no public advertisements through any media, marketing or distribution channel, no requirement to file forms with the ROC and SEBI, only two things: allotment within 60 days of receiving application money and filing a return within 15 days from the date of allotment, giving details of name, address, number of securities allotted and such other particulars. If the company is not able to allot within 60 days, it shall repay the money within next 15 days, and any delay shall attract 12% per annum interest from the expiry of the 60th day. No fresh offer is allowed unless allotments of an earlier offer have been completed. Any offer not in compliance with the provisions of section 42 shall be treated as a public offer for all purposes. As regards the golden rule on framing of prospectus, the true nature of the company's venture should be disclosed. Everything must be stated with strict and scrupulous accuracy. No fact should be omitted, the existence of which might affect the quality of advantages held out as inducements. As regards expert, he can seek protection from the misleading statement by asserting that it was a correct and fair representation and he had reasonable ground to believe that the person making the statement was competent to make it. Peake versus Gurney talks about remedy for civil liability available only to direct allottees, not to people who subsequently buy shares on the stock exchange, as happened in case of Peake versus Gurney. Court held directors cannot be made liable for all subsequent dealings upon stock exchanges long after the allotment has been completed. R versus Kilsant is a case where statements deemed to be untrue, like company regularly paid dividends, was indicated, but in fact the company was into losses and the dividend was being paid out of accumulated profits. As for criminal liability, where a prospectus includes a statement which is untrue or misleading, every person who authorizes the issue of such prospectus shall be liable under section 447. Any person who knowingly or recklessly makes any statement, promise or forecast which is false or deceptive or misleading and deliberately conceals any material facts to induce another person to subscribe or underwrite securities, and such person shall be liable for action under section 447. Punishment as specified under section 447: a person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of turnover of the company, whichever is lower, attracts imprisonment for a term not less than 6 months but which may extend to 10 years. Where the fraud question involves public interest, the term of imprisonment shall not be less than 3 years. He shall also be liable to fine which shall not be less than amount involved in the fraud, and it may extend to 3 times the amount involved in the fraud.